I'm Stella Creasy. I'm the chair of the Labour Movement for Europe. I'm very pleased we've got a really good panel for you this evening, which is brilliant because this is a really important issue. The EU retained law bill, I've been explaining to people, is a bit like we are in an economic crisis right now. We've got a cost of living crisis, so the house is on fire. The EU retained law bill is a bit like bringing a block of Semtex in and throwing it into the mix. It is one of the most destructive pieces of legislation I've ever seen in my 12 years of being an MP. And that's why I'm really pleased tonight we've got with us George Peretz from the Labour Society of Lawyers. He's also an expert on trade law, who is going to explain quite what a retained law is and why this is so destructive. We've got Bruce Robin from the trade union Unison, because in particular, this bill rips up thousands of pieces of employment law that many of us have relied on for years and are the bedrock of good employer relations in this country. And crucially, we've got Justin Madders, who is the Labour frontbench spokesperson, who has the unedifying task of leading the charge against this legislation, which starts in Parliament tomorrow. Over to you, George.
Yeah, absolutely. Well, what's retained EU law? When we left just after Brexit, the then government, the May government, took the view that you needed to keep large parts of EU law running in the UK, even though we were no longer a member of the EU. And that was because in vast areas of our law, EU law is what there was, or the domestic law was full of holes and EU law plugged them. And rather than try and rewrite all of that at once, the view was taken, just keep it going, keep all the instruments going, keep all the EU legislation that applied going, and put in some legislation to support all of that, but basically leave things as they were, subject to some changes that were made immediately on Brexit. Most obviously, the free movement rules all vanished, and so on. And the idea then was to let Parliament slowly go through what was left and decide whether it needed changing and how. So that is retained EU law. It's nothing to do, there are things it isn't. It's not about the Northern Ireland Protocol. That's a completely different issue and a completely different bill. And it's not about the citizens' rights provisions that protect EU citizens who are over here before Brexit. That's, again, a different set of issues. This is about the sort of decision which we made voluntarily. We never agreed it with the EU, that we would keep EU law on and slowly go through it and replace it. Right, now, the right wing of the Conservative Party has been unhappy with that because it finds that people like me are still standing up in court and talking about EU law and inviting the court to look at ECJ cases, and they find that objectionable. So what they want to do is to clear the whole thing out. And when I talk about the whole thing, I'm meaning really quite important rights. For example, working time regulations, your rights not to have to work too long at work, your rights to compensation if a plane that you're about to fly on is cancelled, your rights if somebody takes over your employer's business, a lot of people will know as TUPE, and all sorts of other rights that you've got, environmental regulations, habitats regulations that protect environmentally sensitive sites. These are all retained EU law, and they're all in the form of what secondary legislation that was made by ministers during the period that we were a member state. And all of that stuff, all it retained EU law that's in the form of regulations, anything that wasn't actually written into an act of parliament, as a few things were, is subject to the bill. And what's going to happen under the bill is essentially you've got three things. The first thing that happens under the bill is this sunset clause. So all the retained EU law that's in the form of regulation, so all the rights that I was just talking about, what clause 1 of the bill says is that those automatically fall, they disappear on the 31st of December 2023. However, it says ministers can, if they want to, either postpone that cliff edge or just get rid of it entirely. But the bill leaves that choice entirely up to ministers. There's nobody gets any say in that. There's no parliamentary vote. It's just ministers' decision. They don't even have to consult anyone. So that's the first thing the bill does, is this cliff edge. The second thing it does is it gives ministers enormous powers to rewrite all of this law. Now, rewriting could mean different things. It could mean trying to rewrite it so that it says much the same thing, but avoiding EU law or terminology and using sort of UK law terminology. That sounds fairly inoffensive. But rewrite also means completely gutting. It can mean, for example, if you take something like the cosmetics regulation, which sounds very boring and quite often is boring because it tells you about how much chemicals you can put in cosmetics, but it has some features that are quite interesting to an awful lot of people. For example, it bans the sale of cosmetics that have been tested on animals. So ministers, when they decide to replace the cosmetic regulations, could quietly drop that bit if they wanted to. They rewrite it out. And endless examples, employment law, environmental law, they could sort of do something which was a bit like EU law that they're getting rid of, but it's stripped of large parts of its content. The only thing they can't do under the bill is they can't increase rights and protections because the bill specifically stops them doing that. So this is a downwards ratchet. It's downwards only. And when Rees-Mogg talks about are being free to have better standards than the EU, well, there's nothing in the bill that supports that, and indeed the bill stops that. So that's the second element of the bill, is this extraordinary rewriting power, which again, no consultation is required, and in many cases, Parliament doesn't get a vote at all, so no scrutiny. And then the final thing the bill does, which is rather more complicated, and I'll just try and just take it very simply, the bits of retained EU law that are left, what the bill does is it fiddles around, to put it in a non-technical way, with the way in which that law is interpreted. Basically, the dogma is you've got to get rid of all case law. You've got to stop people like me being able to refer to the European Court of Justice case law and to EU law principles when we're arguing about what these regulations mean. So all of that is stripped out. The courts are going to be told not to refer to general principles. They're going to be invited to ignore ECJ case law. The upshot of all of this, it sounds all very technical, but the upshot of all of this is that what the remaining law means becomes extremely uncertain, because all the crutches that you normally use, that lawyers would normally use to advise clients about what the terms mean, all disappear and you have to start again. So it's a recipe for huge uncertainty, indeed in some cases legal chaos. And why is this being done? Well, it's being done simply because of a dogmatic belief that nobody should ever be allowed to refer to the European Court of Justice or to EU law in an English or Scottish court. Summing all that up, what you've got is a bill that's both anti-democratic because it gives these enormous powers to ministers to let huge areas of law just fall away without any scrutiny at all, to rewrite it more or less as they want. And it also makes the regulatory environment extremely uncertain because it fiddles around with the interpretation of the law that remains. It means that if you're investing in the UK, you simply won't know what the rules are going to be about employment, about environmental protection, about the product standards that apply to your particular product. You'll have no idea. All you'll know is that regulation is going to come leaping out of ministers' heads at a moment's notice and without your having any ability to comment on it or try and improve it. So none of this is creating a good atmosphere for business investment, to put it gently. And that's why, I mean, I've got an article in The Guardian coming out tomorrow, which you can look at if you're interested, but I describe the bill as being both anti-democratic and anti-growth. It's important to oppose it.
Thank you, George. I think that was incredibly helpful for people as a basic primer in this destructive piece of legislation. I'm now going to turn to Justin as the front bench spokesperson who is going to be leading the charge against this legislation. And then I'm going to ask Bruce if it's okay to just explain a bit more for people how employment law is used, particularly on a day-to-day basis, and so why this is so problematic. But over to you, Justin.
Yeah, thanks, Stella. Thank you, George, for that introduction, because I think you've set out very clearly and helpfully what this does, and it's one of the most dangerous pieces of legislation I think we've seen in Parliament, because it's not what it says in it that matters, it's what will happen afterwards, and we just simply don't know what is going to happen, because we've had virtually no word from government about what they intend to do with the some 2,500 regulations that are currently covered by this bill, and it's actually the case that they probably don't even know all the legislation that is covered by the bill, because I think Stella's had that confirmed today, that there are actually several other regulations that don't appear on the dashboard. So it's an incredibly strange situation where rather than the government say, these are the things that we want to keep, these are the things that we want to change, and these are the things that we want to revoke, we face a bill that simply says, we will do all of these things, or some of them, but if we don't do anything, they all fall automatically at the end of next year. And there isn't even a list of regulations that are covered. We are directed to this dashboard where you have to type in search terms to find relevant regulations. It's almost as if they didn't want us to know what they had in mind. And I think that is probably where we need to be focusing our attempts to persuade Tory MPs in particular that they shouldn't be supporting this, because if they vote for this tomorrow and then in 12 months' time they find that, for example, rights to holiday pay have been taken away, or some other regulations to do with protecting wildlife habitats have gone, it's too late for them to say then, no, I didn't realise that was what was going to happen, because that is exactly what could happen under this bill. So, as has already been set out, this arbitrary date of the 31st of December 2023 has been identified as the magic date by which all regulations will fall. And as George said, the real danger of that is that nothing needs to happen after this bill is passed. It simply just falls off without any further action being taken by a minister. So there's no obligation to consult. There's no references to impact assessments, equality impact assessments. There's no engagement with groups that might be affected. The minister simply has to do nothing, and it falls away. And that is a very worrying situation for us to be in, because as you all hear and no doubt already know, there are lots of things in there that I don't think anyone, or apart from Jacob Rees-Mogg, who voted to leave the EU, actually wants to see the back of. And particularly as a shadow employment rights minister, that's the area I'm most concerned about. And I've no doubt that the working time regulations and the right to paid annual leave, the right to rest breaks daily and weekly, will be coming under intense scrutiny from Jacob Rees-Mogg. But there are other things. There's two pieces we mentioned. If at the moment, if the owner of the business changes, you've got certain rights and protections that could simply just fall away. Stuff in there about preventing discrimination against part-time workers, agency workers. We know that's something else that's in Jacob Rees-Mogg's sights. I won't steal Bruce's thunder too much, but there's a lot in there that we need to be extremely worried about. And on the environmental side as well, there's lots of stuff about protecting habitats, about protecting our waterways as well, and the sea that simply isn't going to be there unless the government actively choose to keep it. And then the other thing in the tail is that if they decide they want to keep some regulations, as we've already heard, they don't have to keep them exactly as they are now. They can water them down in some way. And if we take the right to paid annual leave at the moment, that's 20 days under EU regulations. They could turn around next November and say, oh, we're going to keep the right to paid annual leave, but we're going to put it down to 10 days rather than 20. And we would be in a very difficult position in Parliament, because it would be presented as a statutory instrument, and you may not know that you don't get a chance to amend those. You either accept them or reject them. So we would be really faced with an invidious choice as to whether we accepted a reduction to 10 days for paid annual leave, or if we rejected it, there would be no paid annual leave at all. And that is the stark reality about what we are being faced with. And of course, as George has already pointed out, how on earth anyone can advise businesses about how they're going to be operating during this period is anyone's guess. There is no physical way that if the government wanted to keep the majority of those 2,400 statutory instruments, that they could actually find the parliamentary time to do it, it would be simply unfeasible, and certainly there wouldn't be any level of proper scrutiny or examination of regulations that you would want anyway. So all in all, we will be opposing this. We think that for all those Brexiteers who want to take back control, they wanted to take back control for the British Parliament, not for the government to decide what they do without actually reference to anyone else. So we will be opposing this and pushing this very hard on the democratic point, never mind all the rights and benefits of these rules that we currently have being lost. So a lot at stake tomorrow.
Thank you, Justin. And I think all of us are wishing you well in terms of the fight that's ahead on this, because the trouble with the current political climate is that people are distracted. And I don't think a lot of our colleagues, especially on the government benches, realise what they are voting for. Members of the LME might be interested in the list in the invite to this seminar of our deregulation dozen. I have to say, there is many more than a dozen different things that we found, but we would flag to your attention rules about not having cancer-causing chemicals in cosmetics, for example. The requirement that if your firm goes bust, you still get at least 50% of your pension pot. Again, also up. Preventing the trafficking of illegal guns, because obviously we wouldn't want laws on illegal guns crossing borders. Having the same rules about airline safety, so that a plane is airworthy when it leaves the airport as when it lands. Your rights to compensation if your flight is delayed or if your luggage is lost. But probably the areas that people are particularly aware of already are, as Justin says, about environmental protections and what people call sites of special interest, which is why organisations like the National Trust and the RSPB are terrified by this legislation, and employment rights. I'm going to hand over to Bruce now, just to ask him to give people a broad overview of just some of the employment rights, because there are literally thousands of them in this, both in terms of direct laws and then indirect consequences of some of the things that they're talking about. And just to ask him to explain how his union, Unison, feel this could affect their ability to do their work. Because even if the government, and we all know this is the government that came up with the Beecroft report, were committed to replacing or at least bringing back some of these legislation, what just the uncertainty would do. So Bruce, can I bring you in now, please?
Yes, thank you very much, sir. And thank you very much for the opportunity to speak this evening. This is unfortunately a very shocking piece of prospective legislation that is on the table. And the first point, as both George and Justin have made, is that it essentially turns off a substantial proportion of employment rights. And I will go into some of the detail about those in a moment, but it's because British law will be essentially looking to exclude a number of provisions from EU law that previously applied. So depending on your level of engagement with EU law, matters such as direct effect and the supremacy of EU law and the general principles of EU law, for employment rights lawyers, and I've been with Unison for a few years, and prior to that was in private practice representing workers and trade unions on individual and collective employment law. EU law was very much a part of the very rich fabric of employment rights in the UK. And essentially, if you were to break a stick of rock in half, EU law would be imprinted within the British legal system for employment rights as a solid grain. And the mere task of trying to disentangle and unpick the best part of 50 years worth of not only legislation, but case law, particularly in the UK, is just unfathomable. And a very big part of what this bill does, which is a point I'm sure George could speak to in a bit more detail, is the way in which it puts a very, very difficult burden on judges in the lower courts and in the tribunals to try and take on that task of trying to decide cases in the future, which would routinely involve interpretation of British and EU law, but in a way that is hopefully, if they can get their head around it, to try and make clear which parts of the law continues to apply. And the bill does provide for the lower courts and tribunals to refer such matters up to higher courts to decide. But the problem with that is that it will essentially lead to the Supreme Court having to decide everything to ensure that there's consistency between the devolved nations. And this huge task, bearing in mind that there are, as I think Stella was saying, literally thousands of pieces of legislation, means that there will be, without considerable increase in resources or recruitment of senior judges, there will be an enormous backlog. And there is already, of course, a backlog from the systemic problems that have affected the courts and tribunals for many years, and that was before the pandemic. But in the context of employment rights, the type of work that I do routinely and the type of work that my union does in terms of representing working people, every aspect of your working life, pretty much, whatever your background, whatever your interests, will be affected in some way, shape or form by EU law. And aside from the specific points that I think Justin was touching upon and George mentioned, there's a very, very important and significant issue I think that needs to be kept in mind, is that most of these laws, such as rights in relation to parental leave and rights for part-time workers, they impact women much more than they do men. And a very substantial part of these laws, if they are removed, will be to essentially put the progress that's been made over many, many decades for working women very much, put it very far back behind the rest of Europe, certainly, but also the rest of the world, because essentially it is taking away an opportunity for employers to work flexibly with their workforces to enable working women in particular to be able to enjoy certain amounts of protections so that they can continue working once they become a parent. And in terms of the sort of the headline points, if you like, in terms of the specific employment rights, the paid holidays are probably one of the most significant aspects of the bill, which are probably very much within a certain part of the Tory party's crosshairs. But these are rights which have incrementally over many, many years and through many, many different cases that have been run by not just individual workers, but also by trade unions themselves, they've looked to establish a relatively settled basis upon which workers know where they stand and employers know what they have to do. And trying to remove those in one fell swoop will lead to significant uncertainty, and it will lead to, I'm sure, an enormous headache for many HR people and the way in which they manage their business. But it'll also lead to, I'm sure, a great deal of uncertainty for workers in terms of knowing if they want to book their summer holidays or their Christmas holidays, what are they actually entitled to? How far do their contractual rights go? And if they do have the wherewithal to be able to bring a complaint to an employment tribunal, aside from the ongoing delays with that system as it stands, how quickly, if at all, will they get any form of recourse for their concerns about this? So there are, I'm sure, as Justin and George were both saying, some very significant concerns with the fact that the rights will effectively be turned off at the end of December, and the considerable uncertainty about this government and what they will do in terms of any replacement. An important point needs to be borne in mind in terms of those regulations. If they are intending to replace any parts of the bill, they can only be proposed, presumably, once the Act has got royal assent. And who knows how long that will take and how little time will be left for any discussion or scrutiny about those proposed regulations. And already we're hearing from our friends and colleagues in, for example, the civil service unions, and our members there too, of course, about their considerable worries about how they're simply going to process the amount of work that will be needed. When you think, for example, the Withdrawal Act and the legislation that preceded that took 2 years of planning, and a huge amount of resource went into that. And this is essentially attempting to do as much in far, far less time. So it's, I'm afraid to say, a very shocking and concerning situation. And I'm sure that Justin and the other colleagues within the Labour movement who look to challenge this will have plenty of examples. I know Unison, we launched a campaign to try and get our members' impressions about what this bill will mean. The end of last week, I think it was, and within 3 hours we had over 200 responses, and within 24 hours we had over 600 responses of people explaining their concern and horror essentially about what this will mean for them and how it will essentially take us back to the 70s in terms of particularly for women's rights. So I'm sorry it's all very doom and gloom, but of course it is encouraging that at least people are starting to get a handle on this in terms of understanding the significant implications. And of course it's hugely encouraging that people such as Justin and Stella and of course Georgia are very much involved with all of this, so that hopefully we're able to convey the concerns of people and ensure that this bill is challenged in the most appropriate way possible.
Thank you, Bruce. We take a leaf in the Labour Movement for Europe out of the trade union movement, and we say don't mourn, organise, and that's what this evening is very much about. So we want to make sure our members are fully aware of quite what this bill does so they can help us spread the word. Justin is the front bench spokesperson. He's leading on this work. We are doing our best to try and support him. We want you as the members of the Labour Movement for Europe to help us get the message out there about how destructive this legislation is, but also to help us work with as many different organisations as possible to get that message to those MPs, especially on the government benches, about what they're about to vote through. Because Justin needs us all to stand behind him as he gives it some welly, and he'll do that tomorrow, and I know he'll do that in committee. Well, I'm going to ask our speakers for their final remarks.
This bill has, with surprising, more often than not, there's a bit of a debate about what goes on, but this has galvanized, and certainly all the different advisors in employment law from their different backgrounds and different client bases they have are all saying with a very clear single voice, this is bad news, and it is uncertain, and it creates problems not just for, as I would obviously say, for workers and for unions, but particularly for businesses. And it's the uncertainty. That's the big problem, is the uncertainty it leaves. So I'm very grateful for the opportunity to sort of speak this evening, and I obviously look forward to continuing a working relationship with everyone here. And yes, I'm sure the other speakers have got other points they want to raise too.
Thank you, Bruce. I'm going to bring in George now.
Yeah, well, I mean, conservative Labour lawyers will do what it can, but there aren't that many of us. One of the things we will be doing is thinking, and indeed the professional bodies, the Bar Council, which I'm also involved with on this, has been doing quite a lot of work. And the Bar Council put in a report of evidence to the European Scrutiny Select Committee, which is Bill Cash's committee, which is a bit of a Brexit knitting circle, but we put in some evidence to that, which was pretty critical of the idea. So I think there'll be a lot of ideas for amendments flying around, and work is going on behind the scenes on that, as I think Justin's aware of that's happening behind the scenes, and at some point, and Stella, and I think at some point we will need, amendments will need to be discussed. I mean, I think the reality, and Stella and Justin will confirm, that in the Commons, it's quite unlikely that any of these amendments are going to get anywhere, particularly as with a sort of new leader and perhaps Tory MPs slightly less willing to rebel within 2 minutes of his taking office. But in the Lords, there's real concern about this. There was a very good speech by Lord Judge, who's the convener of the crossbench peers, former Lord Chief Justice, just after the Queen's speech in May. And he said he was not prepared to vote for huge powers for ministers ever again. And it's time that the House of Lords plucked up courage and started striking them down. Well, this bill contains huge powers for ministers. And if the House of Lords means it, and I think Lord Judge did mean it, they are going to start voting a lot of these powers down. And it's going to be interesting to see how far the current government pushes it in the face of what I think is going to be quite strong opposition from the House of Lords. There's also a lot of opposition in the House of Lords because so many of them are senior lawyers to proper bits of the bill that just make a mess of the law for no real purpose. And you look at this, you think, why on earth are you doing it? And the only reason is they've just got a bigger, and it's basically bigotry. They think anything comes from the EU has to be rewritten because it's bad. It's as blatant and unreasoned as that.
Thank you, George, and we look forward to working with you. I hope, and I'm not giving away any shock factors, I hope that we can prove you wrong, that we can do something in the House of Commons.
It would be wonderful if you could, yes. Yeah.
Justin, can we give you the final word on this, the person leading the charge in the Commons?
Well, thank you for giving us the opportunity to debate this tonight. It's been good that we've got the message out there a little bit more. We've got to keep doing that. I think that as has been pointed out, not a lot of people know what is coming down the track, and we will certainly be trying to pin down the government as to what they actually intend to do with this legislation, because I think it is so telling that they have said so little about what they want to do. But it's also an opportunity for us, because I think we can put pressure on individual MPs to commit that they won't support anything that reduces environmental rights or workers' rights or whatever area we're talking about. And I think what George said about the Lords is right as well. They will be pretty unhappy at this quagmire that's going to be created for, well, I've still not really heard what the benefit of it is. And picking up the point about businesses, we are engaging very regularly with businesses. I think there is a much more open willingness to talk to businesses. They are very interested in what we've got to say. They see us as a serious and credible alternative to this government, who they don't see as credible or serious at the moment. And I think that the general principles George has said, that the government operate on, if it's come from the EU, it must be bad, is a rather silly one, to say the least, because I don't think that people, if you really ask them, would say that the right to paid annual leave or rest breaks are bad things at all. They're things that actually we've benefited from, and we should do everything we can to protect them. So there are a number of ways that we will be able to do that. Whether we succeed or not, time will tell. But I am very keen to work with whoever on amendments that we might want to put forward to try and give the government as an uncomfortable time as possible dealing with this.
Thank you, Justin. And we as the Labour Movement for Europe will do our best to try and help you make lots of people feel very uncomfortable about this legislation. Can I thank all of our speakers this evening? I'm sure you will agree, having heard about this legislation, just how important it is that we get the word out about how destructive it is. Whatever way you voted in the referendum, nobody voted to write into law a race to the bottom on basic rights, whether it's environmental, consumer or employment rights. Yes, that's what this legislation does. And I think we're all agreed that this government has deliberately tried to hide quite what this legislation does, in the hope that people will think it's a dry technical piece of minor amendments and changes, and people won't realise quite how draconian it is. That's also why it's really important, all of us who are passionate about having a really close working relationship with Europe, that we can't allow them get away with claiming this is about rejoining the EU, because this is absolutely about our basic fundamental rights and freedoms and how we protect them. If you go to the Labour Movement for Europe new website, I hope you've all enjoyed it since we put it up, you will find that there is some sample text, as I said earlier to Claire, that you can use to write to your MP. Please do write to your MP, especially if you have a government MP. There is also a briefing about this legislation. Please do share that briefing on your social media. Help us get the word out. If you're not already following the Labour Movement for Europe on Twitter or on Facebook or even on Instagram, please do follow us. We'll be putting up content and updating you on the progress of this bill. It is a place of flux right now in Parliament. We don't know how the new Prime Minister is going to respond to it, but we can't afford to wait for Rishi Sunak to realise quite how destructive this legislation is, not least because it will damage further what little reputation we have left in Europe and our ability to build those positive relationships we know a Labour government wants to have. So we need your help as members of the Labour Movement for Europe to win this argument, to support what Justin is doing and make that positive case to frankly take back control of this country's relationship with Europe and to start with this piece of legislation. I hope that you're all ready for that fight. I hope you will listen to our trade union colleagues like Bruce when we talk about don't mourn, don't organise. And we hope that we can do George proud with all the amendments we're going to ask him to help us to write in the coming weeks. With that, we're only 7 minutes over time. I'm going to leave you. Good night, everybody, and thank you for joining us. And thank you again to our speakers.